Alright, so I got this pretty well figured out. So, the conditions of the surety bail bond. Alright, the defendant must return to the office immediately upon release from jail. Done. The defendant must appear for all required court cases. Okay. The defendant must contact all pro bail bonds after each court date at the following number. We'll do that. If the defendant fails to appear in court, she must contact all pro bail bonds immediately to avoid surrender back to custody and or additional fees. Okay, so I could not go and get a hold of them. And then it says, all pro bail bonds, fee for failing to appear, all right, at any required court date is $200. The defendant and or indemnitor must contact all pro bail bonds if any change occurs with respect to his or her residence, employment, or phone number. All right. The indemnitor and defendant are responsible for all bail bonds until the bonds are exonerated by the court. All right. That one's huge. So the indemnitor and the defendant are responsible for all bail bonds until the bonds are exonerated by the court. And the premium due for said bail bond is fully earned upon the defendant's release from jail. The fact that the defendant may have been improperly arrested, or his or her bail reduced, or his or her case dismissed, shall not obligate the return of any portion of said premium. Alright, so no refunds will be issued after the defendant has been released from custody. So, no refunds. The indemnitor and myself are responsible for the bond until the court exonerates it. And there's no indemnitor. No indemnitor. So, no refunds shall be issued. So, the indemnitor is not getting a refund because there is no indemnitor. I'm not getting a refund. And All Pro, alright, is basically liable if they don't show up. Meanwhile, I cannot show up and just call them. So, what I'm thinking is, I don't go, right? Let them know. No one's going to be able to get a refund out of this. I'm not going to be able to get a refund, that's for sure. All right, but I'll handle all my obligations, the conditions of the surety, by basically not going and then calling them. So then, the surety bond itself has a promissory note. So, the promissory note, on demand without grace, we the undersigned, promise to pay, to the order of all pro bail bonds, the premium balance pursuant to obligations set forth in the indemnity agreement, guaranteeing the full payment of premiums in consideration for the bail bond posted on behalf. Well, if you read the indemnity agreement, as soon as I am released from jail, the premium is paid in full. So, on demand without grace, we, the undersigned, promise to pay, to the order of all pro bail bonds, the premium balance pursuant to the obligations set forth in the indemnity agreement, guaranteeing the full payment. Alright, so I've promised that when I get released, that they get their full principal. And the indemnity agreement says this as well. So the promissory note promises All Pro that they'll get paid. The indemnity agreement guarantees that they'll get paid. But there's no indemnitor. No indemnitor. So, as soon as I'm released, the balance is paid in full, and there's no indemnitor that is owed anything for this obligation. So it says that the indemnitor and myself are responsible for this. So if default occurs, the entire balance becomes due immediately. Well, there is no balance. I've been let go. So if default occurs, it's already paid. In the event that a suit is instituted to collect this note or any portion thereof, the undersigned promises to pay such additional sums as the court may adjudge reasonable, such as attorney's fees and costs of instituting said suit. I understand this as an application for a type of credit, and I authorize review of my credit history via credit reporting. So, if I pay for the paperwork for the court to handle the default, I'm good to go there. So I go to court, I pay the $25 to file the summary judgment. There is no indemnitor. My principal has been released already to All-Pro, so I don't owe them anything. And there's no indemnitor. Now, to get this proven out and make this happen, I have to get the courts to move. Not to make a motion, I go in and I get the courts to move. So, if you take a look at the bail bond premium receipt and statement of charges, it says the amount received was $0. Alright. The bail bond amount, $15,000. Bail bond premium, $1,500. Itemized expenses, if and is permitted by applicable law. The commission rebate, well, I'm the one that commissioned it. They created it. I commissioned it. I would be the commissioner here. I basically asked them to set out on my charter to get me out of jail. That's totally reasonable. And so the total charges, premiums plus any itemized expenses, $1,200, amount paid $0, balance due, $1,200. But this, all other documents executed by the defendant, indemnitor, me, or other party related to the bail bonds, are incorporated into and made a part hereof by reference. So all the other documents, which includes the indemnity agreement that says they're paid in full upon my release. So this, the total charges and anything due, is taken care of through the indemnitor, which doesn't exist, and the other agreements. Well, it's not my fault that there's not an indemnitor. So, all other documents executed by the defendant, indemnitors, me, or other party related to the bail bond are incorporated into and made part of hereof by reference. So, up at the top, more fine print, I understand that the premium owing or paid is fully earned upon the defendant's release from custody, and the fact that the defendant may have been improperly arrested, rearrested, the case dismissed, or the bail reduced shall not obligate the return or forgiveness of any portion of the premium except as otherwise provided by applicable laws, if any, as stated in an addendum attached to the bail bond application and agreement. So I just have to explain all of this. It's automatically incorporated along with everything else. I don't have to have the indemnitor agree to it because there is no indemnitor. So I come up with my addendum attachment on the addendum attachment, put in plain language that all of my contract obligations are and will be handled appropriately, which they will be, and if I don't, I will be in trouble. The promissory note, balance is paid in full already. There's no indemnitor. The promissory note's good to go. I've already gone over that, but I'm just reiterating. And then here's the best part. There's no depositor. I shouldn't have even been in jail. There is nobody laying claim to have deposited to me. I was just kind of magically there. So these people with no indemnitor and no depositor, so no one to have put me in the situation, and no one to cover the other party's liabilities, the indemnification, they've taken it upon themselves to issue a bond, which was paid in full on my release, with no other parties involved. There's no indemnitor, there's no depositor. So I'm not under any obligation to any depositor, because there isn't one. I'm not under any obligation to any indemnitor, because there isn't one. And so it comes down to my obligations.